Keith, there you go.
Okay, so I'm Keith Huffman. Kristen Belinsky's with me. We're going to go over what we call estate planning 101. I think at the end of the day, you're going to say it's more like 501. We're actually going to talk about some changes in how you sign your wills and how you sign your powers of attorney, which may be effective immediately, may not be. We don't know yet. Talking about some changes in how we sign healthcare documents. We're going to talk about the Secure Act, which is a very, very confusing law. So we call this the Estate Planning 101. And
I can navigate the slides.
Yeah.
With the computer.
Yeah, so you go ahead and move that forward one.
I thought. Oh, hold on. Sorry.
So we could call this keeping the gold in the golden years. All of our clients want the same three things. They want to be treated with dignity. They don't want to be a burden to anyone, but they want to see most of what they work hard for all their lifetime go to their children and not to the state of Indiana and not to XYZ nursing home. And all of our clients want their property to go to their children with the minimum of red tape and the minimum of expense. And the real question is, how do we go about doing that? None of you are paying us today. So as a general disclaimer, we're giving you information which is a general nature, and we're not providing specific information for you that could be viewed as an attorney-client privilege. So with that, Kristen, I'm going to turn it over to you so that you can kind of start the presentation today.
Thank you, Keith. So this slide kind of gives a little bit of an overview of what we're going to go through today. I'm going to take the first couple of topics, talking about wills, maybe trusts, and non-probate assets, and then Keith's going to talk about our powers of attorney and our healthcare advance directives. So that's kind of a brief outline of what we've got coming. So the first topic we've got is wills and trusts. So we use a will as a very basic and fundamental estate planning document for every client that we do estate planning for. Trusts are a great tool. They provide a lot of flexibility, but we don't necessarily use them for everyone. So we're going to touch just a little bit on when you may or may not want to look into trust planning. But first, we want to talk about wills. But first, even before we talk about wills, let's talk about what happens when there's not a will. So some clients come to us and they have this misconception that if someone dies without a will, I've heard people say, well, the state takes your stuff, don't they? And that's not quite true. But if you don't have a will, the state does write your will for you. They create our Indiana will. And this is known as the law of intestacy. Someone who is intestate does not have a will. You don't need to worry about the ins and outs of intestacy. It's kind of complicated who gets what. What you want to remember is it's never what you actually want to happen. I've never once seen an intestacy situation where everyone was happy. In general, the spouse doesn't typically get everything, which can be a very unexpected consequence. The children are involved. Sometimes the deceased person's parents get a distribution. It's even worse in a subsequent marriage situation. In a blended family, the spouse gets an even smaller share, and that can be a very unexpected and unwelcome development. So really, it's very important as a fundamental for estate planning that everyone have a will. At its heart, the will is the document that says what happens to your stuff when you die. You make gifts of all your different types of property. You can make gifts of your tangible property, your money, your real property. You can make specific gifts to specific people, leave grandma's wedding ring to your daughter, leave grandpa's shotgun to your son. And then you make residuary gifts, which means who gets everything else, whatever's left over in the residue. And a lot of clients want to make charitable gifts too. Not everyone, but that's something that's important to a lot of people. The will appoints your executor. Indiana law actually uses the term personal representative, but the term executor might be more familiar to people, meaning the person who's in charge of the probate process. And then as an important thing for clients with minor children or who are caring for someone, a disabled adult, like a disabled adult child, the will allows you to make guardianship provisions. So naming your successor in caring for those loved ones. So those are kind of the most important and basic functions of the will.
And might I add that you can now add your digital assets or your electronic assets under your will.
That is true.
And you might want to consider where you've named your spouse as your personal representative, Maybe you're gonna name your grandson as the person representative for your digital assets or your electronic assets.
Not trusting your spouse to know how to clear your browser
That's
history.
correct,
Okay,
yes.
yeah. Yes, that is an important point. And along the lines of electronics and the advancements that we're seeing with digital assets, there is a pending bill, or a bill that has been passed by both the Indiana House and the Indiana Senate, and we believe it was actually signed this morning. We're not 100% sure. The Indiana Legislative Bill Tracker is not updated yet, but this new law will actually really revolutionize how we sign our wills. We are now able to sign wills and powers of attorney completely electronically via video link. A lawyer does need to be involved for the formal assembly of the document within 5 business days, but we can now do that. This is actually, I think, it was in the works prior, but the pandemic really kind of hustled this type of legislation along, because a lot of us in this line of work have been scrambling and struggling during the pandemic to get access to people who need to sign documents. A lot of nursing homes have been locked down for long periods of time during the pandemic. So this will make that easier going forward. And also now, if this bill is in fact signed, which we believe it is, we can now sign documents entirely electronically, meaning wills, trusts, powers of attorney can now be signed without a quote unquote wet signature, meaning no one's putting pen to paper. They are entirely an electronic asset or a digital asset now. But I did note that digital wills, meaning wills that are signed via video link, as we talked about, those still have to be signed, so to speak, in person, or I'm sorry, they must still be signed in person. So yeah, a will that does not have a wet signature must still be signed in person. A will that is signed via video link must be signed via wet signature. So you can't do both. That would be too much advancement in one document. So we get a lot of clients who come in and they have been told by their neighbor, their uncle, whoever, that they have to have a trust. Well, what kind of trust? Well, I don't know. Well, what you tell me. So what is a trust? At its heart, a trust is a separate legal entity that owns property, and the property is managed by someone, the trustee, on behalf of the beneficiary of the trust. Trusts are really customizable. So whatever needs you may have, whatever reason you don't want someone to own property outright, the trust can work and can be flexible and customized to that need. There is also a common use for trust is to delay inheritances for young beneficiaries. So if someone has minor children, they certainly don't want their minor children inheriting a lot of assets. We use trusts to delay those distributions if parents die when children are young. Another option is a custodial account. A custodial account is not a trust. It functions in a similar way. It's money that's managed on behalf of a young person. The primary difference, custodial accounts are simpler to set up and simpler to run, but they terminate in their entirety automatically at age 21, versus a trust that you can delay out to whatever age or whatever time frame you choose. So it's really a matter of what the client's goals are, and it also can be a matter of how much money we're talking. There's no hard and fast rule. I tend to, if we're in the $100,000 or less range, I tend to kind of lean more towards the custodial account. And I tend to go more towards the trust if we're over that 100,000 mark, but that's not a magic number. It's very fact sensitive, what's best for the client. The question then becomes who serves, if you're setting up a trust for someone, who serves as trustee? You can have an individual trustee, or you can have a professional or corporate trustee. I don't necessarily push my clients in one way or another, but what I tell my clients is they think that a family member or a friend as individual trustee is going to be a great bargain. You're not going to have to pay them like you would a bank or a trust company, and that possibly is true. However, trustees are entitled to take a fee, and an individual trustee, the first thing they should do is hire a lawyer. The second thing they should do is hire an accountant, and the third thing they should do is hire a financial planner, or maybe not even in that order, but so by the time you work in all of that, a corporate or a bank or a professional trustee might actually be a better choice. So these are just all conversations that we have with our clients. Another thing that's not on the slide, but that we need to talk a little bit about is the concept of a living trust versus a testamentary trust. A living trust is a revocable trust agreement that you put in place. It's separate from your will, and you can put money or other assets in it during your lifetime. And these are great tools if you're looking to avoid probate or have someone else managing assets for you. So we use those a lot, but they're not always the type of trust that we use. We might use a testamentary trust, which is a trust that's contained within the will. And these trusts don't come into play right away. They're a backup plan in the will. They're ready to come into existence when a client passes away if certain conditions are met. So, for example, in my plan, I have little kids. If my husband and I both pass away before our kids are 35 years old, trusts get funded for our kids. If our kids are past that 35 benchmark, the testamentary trusts in our wills never get funded. That's a lot of complex information about trusts. What I would like to convey, or what I want everyone to take from it, is that every client's situation is unique. Some clients, we do employ living trusts for a variety of reasons: real estate management, probate avoidance. Some clients don't need that level of complexity of planning. So we really try to take it's not a one size fits all, oh, everybody gets a trust, or you don't need one. We take a fact sensitive client by client approach to that. But yeah, so on this next slide here are some of the reasons or the triggers that we might look at to use a trust for a client. So as I alluded to, if you've got young or even just irresponsible beneficiaries, just because someone's not a minor anymore doesn't mean they should necessarily inherit a large amount of money. There's no magic age to a trust. Parents of young children tend to typically have trusts terminate in the 30 to 48 year age range. But again, there's no hard and fast rule on that. Sometimes in a blended family situation, mom or dad might want to make sure that their spouse is taken care of, but to preserve assets for their side of the family when that spouse passes away would be to maintain and secure the future of a surviving spouse without giving the money outright, making sure the money flows back to the kids at the surviving spouse's death. Definitely, we want to look at a special needs or a supplemental needs trust in the case of a disabled beneficiary. Special needs or supplemental needs, those terms are used interchangeably. They're not two different types of trusts. But really what this type of trust does is it allows money to be held and managed on behalf of a person with a disability, but that's not accountable resource to that person, so that disabled person can continue to receive needs-based benefits like Medicaid, SSI, HUD Section 8 housing, SNAP benefits, all of those things. And then probate avoidance is definitely a use of a trust. You can place assets in a trust and then avoid having to go through the probate process. Sometimes, depending on the client's assets, probate avoidance isn't the #1 goal, but depending on the complexity of the assets and also the complexity of the family situation, probate avoidance can be something that you want to look at doing. And that allows for the convenience of not having to go through probate and privacy. And it also allows for simplicity of dealing with real property out of state. So trusts are a really common tool for us to use for clients who have that Lake Michigan or that Michigan Lake home or a condo in Florida. Those are two really common scenarios.
Kristen, I might interject here that most family trust, loving trust, whatever you call it, revocable trust, don't protect property if somebody goes to a nursing home.
That's a really good point. Yeah. So if a client is convinced that they need a living trust for asset protection, Medicaid planning, that is not the kind of tool that is not one of the benefits that it provides. So just a word, I won't spend a lot of time on this, but special needs planning is something that's very near and dear to my heart. I love doing this. Any family with a special needs individual, special needs child, their estate planning is going to be more complex. The one thing I want you to take from this is disinheriting a special needs loved one is never the answer. It is never the best idea to give all the money else to someone else and trust them or count on them to take care of that person. Special needs trusts are a very flexible tool that we can use to protect and to ensure the future security of a special needs individual without disinheriting, but also without interrupting their needs-based benefits. So if you've ever got a client with a special needs child and they're not leaving them any money, that is not the ideal kind of approach that we want to take. So a word about probate, and we're doing a whole nother webinar on probate here, I think next week or 2 weeks from now. So I'm not going to spend a lot of time on it, but so probate is the formal process when a will is filed with the court, an executor or personal representative is appointed, and that person takes charge of gathering up all the assets and distributing them out. A lot of assets, though, what people don't realize is a lot of assets aren't subject to that process. There are a lot of what we call non-probate assets in Indiana. An asset that is a probate asset is something that's in someone's individual name that doesn't have a TOD, transfer on death, or a POD, pay on death, or another beneficiary designation. So really, a lot of assets are non-probate. The most common examples would be life insurance and retirement accounts and pensions. Those all have named beneficiaries. Sometimes pensions don't even have a death beneficiary. They terminate at death. Anything that's jointly owned is not probate. It is going to pass automatically to the joint tenant. And then anything that has a TOD or POD designation is also going to pass by that beneficiary designation and is not going to go through the probate process. In Indiana, with respect to transfer on death, pay on death, the Transfer on Death Property Act in Indiana allows us to place a TOD or a POD designation on really anything in any kind of property you can think of. Placing a TOD designation on a bank account is quite simple. Financial institution will provide the paperwork for that. We usually just tell our clients to go to the bank and get that done. With respect to real property, that is done with a transfer on death deed prepared by a lawyer, and we file it. Vehicles can be TOD at the Bureau of Motor Vehicles. They have their own form for that. Securities are TOD via a notarized form that a lawyer can prepare. So really, there's not one simple or single way to place a transfer on death designation on anything, but you can really transfer on death designate anything, also including tangible property. My favorite example is I had a client who had some sort of fancy sewing machine that was worth like $30,000. I'm not even kidding you. I didn't know they could be that expensive. But she wanted to make absolutely sure that it went immediately to one of her daughters. And so we did a TOD designation for that sewing machine. So that was my most unique example. Qualified retirement accounts are non-probate assets, and they can be a bit tricky. The most common examples of these are IRAs, 401ks, 403bs. What you want to look for as a financial professional is don't make the estate the beneficiary. Don't name the estate. Don't allow an account to not have a designated beneficiary, because then it will default to the estate. Paying to the estate means it's an accelerated payout. Any qualified retirement money that's payable to someone's estate must be paid out in its entirety within 5 years. And that accelerated payout is obviously going to cause a bigger income tax hit for the beneficiaries than a stretch payout would. You want to name an individual person, you can name a charity, or you can name a trust. There's a common misconception that naming a trust is either not permitted or it's disastrous, and that is not in fact the case. A well-drafted trust, and that's key, it has to be well-drafted. Make sure this isn't a legal Zoom trust. But if a lawyer who knows what they're doing drafts the trust, then the trust itself can be the beneficiary of qualified retirement money, and you can get the same stretch that you could if you named an individual. And non-Roth qualified accounts are a great vehicle for charitable giving. I'm administering a trust right now where we're making over $100,000 of charitable gifts. We are going to use all of the non-Roth qualified money to make those gifts, because those charities aren't going to pay income tax on that bequest as an individual would. So that's a great thing to think about if you have a client who's charitably inclined. Do we have some qualified money that we could use to make those gifts? So the Secure Act, this law is complicated. That's putting it mildly. Very complicated. And we don't. And the other issue with the Secure Act is we don't have regs from the Treasury yet, so we're kind of flying blind a little bit. But what the Secure Act did is, it used to be that an individual beneficiary of a qualified retirement account could get a lifetime stretch of those payouts. The Secure Act eliminated the lifetime stretch payout of qualified money for most beneficiaries. Now, there's still a class of eligible beneficiaries who can still get the stretch. And if you're an eligible designated beneficiary, you get a 10 to 11 year stretch. And I say 10 to 11 because it is 10 years, but they don't start counting that 10 years until the year after the date of death. So if someone dies January of 2021, your 10-year clock doesn't start running until 2022, so you almost get 11 years. So you can get a little bit more than 10 years depending on when the death falls. But these eligible designated beneficiaries are spouses, minor children of the plan participant, but that special treatment only lasts until the child hits the age of majority, and then they're stuck with the 10 years as well. It's a beneficiary who's less than 10 years younger than the plan participant, which doesn't happen often. And then it's most notably a disabled or chronically ill individual or a special needs trust for an individual like that. So that eligible designated beneficiary, the disabled beneficiary, actually provides us with some good planning opportunities. So the special treatment that spouses get for qualified money is preserved under the Secure Act. Spouses can still stretch or roll over qualified money. The Secure Act defines disabled or chronically ill individuals as these eligible designated beneficiaries. Now, the definition of chronically ill isn't anyone who has a chronic illness. It's a chronic illness that is basically taking them to the level of a disability, meaning they are having trouble with activities of daily living. So just because you have asthma doesn't mean you're an eligible designated beneficiary under the Secure Act. There has to be that heightened showing of interfering with daily living. But if you have someone who falls under this disabled or chronically ill category, they can continue to get the lifetime stretch that a regular designated beneficiary can no longer get. So especially if you've got a young special needs individual like a child, they can stretch out the distributions of qualified money longer. And we can get that same stretch if we use a special needs trust for that person. So if you've got a client who's got a special needs individual who's going to be a beneficiary of their estate plan, you've got some flexibility and it's worth getting creative. Keith and I had a client last year, very high asset, very high net worth client with 3 children, one of whom was disabled. We drafted their trust so that a much higher proportion of the qualified money is going to flow into a special needs trust for the disabled child. And then we've got an equalization provision that's equalizing so all the kids are getting the same amount all told, but we're not doing an in-kind distribution of each asset. More of the qualified money is flowing to the special needs trust and more of the other funds are flowing to the other kids.
So what that allows is that the money can be stretched out for the disabled child over the disabled child's lifetime, and anticipating the disabled child is going to be in a much lower tax bracket than the other children. There's a lot of benefit to everyone in the family.
Absolutely. I'm just checking my time here. We're doing okay. All right. So I've got a couple. I get questions now and then. There's a couple other non-probate assets that it's easy to kind of overlook, or I find it easy for me to overlook. One of those is health savings accounts, and I don't do a lot with respect to health savings accounts from a planning perspective. The only thing I tell my clients is if you've got a health savings account when you're married, be sure you've got your spouse as the beneficiary of that account, because spouses, much like with qualified retirement money, spouses can roll over an HSA and continue to use it as an HSA and not get an income tax hit when someone passes away. So that's just something to keep an eye on. If someone's not married, I don't really do a lot of planning with their health savings accounts. And I get a lot of questions about 529 accounts. So you want to definitely name a successor owner of the 529 account. This is different than the beneficiary. So the beneficiary of the account is the person who's going to benefit from this account from an educational standpoint. The account owner is going to be the person who kind of controls how the money is used. So for example, just yesterday I had a client say, I've got a fair amount of money in this 529 for my grandson, and I really don't want my son controlling that money because he's not going to be careful with it and he's not going to do the right thing. So we're naming another child, not the beneficiary's parent, but another child of the grandmother as the successor owner of that account to make sure that a responsible person takes over when grandma dies. So just some information there about 529 plans if you get questions from your client. Just really what I want you to take from this is if you have a client who's working with an estate planning attorney, make sure they're having the conversation about non-probate assets. I can draft, or any attorney can draft, a beautiful will or a beautiful trust, but if you're not looking at what happens to the non-probate assets that are not governed by those documents, you could be overlooking the estate planning with respect to a large portion of their estates. A lot of clients carry a lot of their wealth in their qualified retirement accounts. And if your estate planning isn't accounting for that, if you're not making sure that your planning is dovetailing with what you've got as your beneficiary designations, you're not looking at the whole picture. You've got an incomplete puzzle there. So with that, I am going to flip it over to Keith. And Keith, I can kind of keep clicking, or do you want me to hand you the mouse?
Well, Kristen, I'm not going to let you off that easy.
What? Oh, okay. All right. All right. I'm trying to be done.
So what about minimum distributions about the Secure Act?
Minimum distributions? Oh, well, we don't know. That's the problem. So we've got the 10-year period for the Secure Act. We know that the entire account for a non-eligible designated beneficiary, the entire account has to be distributed within 10 years. The question then becomes, well, do we still have to do minimum required distributions for those 10 years, or can we wait until year 10 and do a full lump sum? Can you manipulate that? And we don't know. The IRS just published a publication where they kind of implied, they didn't really say it directly, but they kind of implied through a couple of examples that during the 10-year waiting period, you still have to do minimum required distributions. But then someone from the IRS said, no, we didn't really mean that, just kidding. And they're supposed to be revising that publication. So we don't know fully the answer to that question. It seems to me, and I'm not a financial planner, but it seems to me that taking it all in one lump sum might be income tax disadvantageous. But we don't have any clear parameters from the IRS as to what we need to be doing. So.
Especially if that child is receiving Medicare, because their Medicare premiums will be greatly increased going forward.
Right,
Yeah.
right. So
once we know the answer to that question, we'll make a post on our website.
Yeah, we'll publish an article on our website. So
yeah.
But we're always happy to take questions if you just want to shoot us an email too. But we don't know the answer right now. So
yeah, one of the other misconceptions that a lot of our clients have is that there's going to be a lot of will contests after they're gone. And there aren't very many will contests.
No, so in Indiana, our laws are drafted so that the person who's filing the will contest bears the burden of proof. You've probably heard the term burden of proof from law shows or something. So if you want to file a will contest, the entire evidentiary burden of proving that a will is invalid falls on the person who's bringing the will contest. And that makes it challenging. Most lawyers will require a pretty big retainer to bring a will contest because they know that the odds of success are pretty slim. And that also can be a barrier to people deciding to ultimately pull the trigger on a will contest. Indiana law also now allows, we didn't have this before. For a long time, Indiana was one of the few laws that didn't allow what we call no contest clauses in wills. But now we have them. And that means you can put a clause in your will that says, if any beneficiary contests this will, they don't get anything. And that can be a handy tool. If you know that one of your beneficiaries is going to be a pain and is likely to bring a contest, you can leave them just enough money that they're disincentivized from bringing a contest. So leave them $10,000 and put a no contest clause in your will, and that's going to be even further disincentive to contest the will.
And how can someone contest a will? What are the?
You file a lawsuit. What
would be the grounds?
The grounds. So that would be, it would either be undue influence. So someone is forcing you to sign a will. And that's not just, putting a little pressure on mom at Thanksgiving. That is truly exercising so much control over someone that you have taken away their ability to make their independent decisions. So you can't bring a will contest on the grounds, well, mom likes Joe better than me and he convinced her to do this. Well, that's just mom listening to Joe. That's not undue influence. The more common grounds for will contest would be incapacity, meaning someone did not have the mental capacity to understand what they were doing. And it's worth noting that the capacity for the standard for capacity in Indiana for signing a will is actually lower than the standard of capacity for signing a contract. So just because someone, for example, is in the early stages of dementia, they may still have enough mental capacity under the law to understand their will enough to sign it. So just a diagnosis on the books of dementia or Alzheimer's or some sort of disability doesn't categorically mean someone can't sign a will. So.
And we don't have any slides about this, but we're actually doing quite a few prenuptial agreements As folks get older and older and want companionship, when one spouse dies, there's a lot of remarriage. They want to make sure that they have it set up so that the assets they bring into the marriage go to their children in the event of divorce or death. They want to make sure that within the agreement, we have it spelled out who's going to make healthcare decisions in the future. Is it going to be the spouse? Is it going to be the family members? We want to have a clause in there about what happens if they go to the nursing home. The state of Indiana is not a party to most prenuptial agreements, and so there's an issue about how valid they are if you end up going to the nursing home.
And another note on prenuptial agreements, I have clients who frequently worry about their children's marriages for whatever reason. I always encourage clients to encourage their children to have prenups. And that sounds very cynical, and I know it kind of is, but a prenup is the only way to prevent an inheritance from being part of a marital settlement. So I always tell my clients, you can encourage your children to get a prenup on that basis, not necessarily on the cynical, you're going to get divorced type of basis. But in the absence of that, and if a client is concerned about a son-in-law or daughter-in-law with respect to an inheritance, the only option you have after the marriage is to put that money in trust and not give it outright to your child. And that is definitely a planning option. But honestly, sometimes a prenup is an easier conversation to have than, here's why I put your entire inheritance in trust, Susie, because I don't like your husband. So yeah, that's a good point.
So you want to move on then?
Yep, you're up now.
Yeah.
So
I tell my clients the most important estate planning document you sign is a financial power of attorney document. So between spouses, you always assume you can act for your spouse, and legally you cannot. So it's important that you have that power of attorney document prepared. The power of attorney document generally would say, I name my spouse to be able to do things for me if I'm incapable of doing them. Most powers of attorney are durable powers of attorney, meaning they become effective once it gets signed. We encourage people to do that. Now, you can put into the power of attorney that it becomes effective upon a certain event. I used to say it became effective upon the Chicago Cubs winning the World Series, but then they actually won the World Series. Go figure, you know? So usually you would say the power of attorney becomes effective immediately. But generally, we don't give the power of attorney document out. So we've named spouse first, and then we've named the kids to be able to act if spouse cannot act. But the kids aren't going to use the document for 10 or 15 years. So we have a little vault downstairs that we keep all these powers of attorney in. And when we're ready to release them, we give the children a little thing about what do you have to do for an accounting? What do you have to do? How do you sign your name under power of attorney? What are your obligations as you act for the rest of the family? So there's a lot of things that go into the power of attorney. We generally say that the power of attorney is unlimited, so they can do whatever needs to be done in there. We also have a gifting clause. The Indiana Power of Attorney statute actually runs about 45 pages long. So when you actually do a power of attorney document, you're bringing part of that Indiana law into your document. So when you say you have general authority with respect to real estate transactions, you can go out and borrow money, you can do a mortgage, you can do a deed, you can deed the property into a trust. There's a lot of different things you can do. We're always interested in what happens if somebody goes into the nursing home. Under Indiana law, if your power of attorney gives you general authority with respect to gift transactions, then you're limiting the amount of gifts that can be given to any one person in any 1 year to $15,000. One spouse goes into the nursing home, we're putting the house and the farm into the other spouse's name, usually worth more than $15,000. So we want to make sure we have the authority under the document to be able to do that. Now, we temper our documents by saying that we're authorized to make gifts without regard to the Indiana annual limitation. But we also go on to say that gifts can only be made to the attorney in fact or someone the attorney in fact supports pursuant to written advice from the person's professional advisor. So we've advised mom and dad. Now mom or dad has gone into the nursing home. We want to save some of what they have. Then with the power of attorney document, we would send out a letter to the attorney in fact saying, we authorize you to make the following gifts in the following amounts. And you can do a lot of planning at that point in time. And so we encourage people to have power of attorney documents. I think it's a lot more important than a will. If you don't have a will, the state has a will for you as you went through the intestate provisions. It may not be perfect, but it's certainly better than not having anything.
You just took the wind right out of my sails, Keith.
I'm sorry about that. But if somebody's incapable of signing a power of attorney, they've waited too long to do this, then we're looking at doing a guardianship. And we've done a lot of guardianships where the courts have actually, one of the considerations in a guardianship is the judge is required to see, would this person, if they were now competent, have engaged in public benefit planning so that they could actually become eligible for Medicaid in the nursing home? Would they rather have some what they worked hard for, like go to their children as opposed to XYZ nursing home? And most judges are very, very accommodating with that and allow that type of planning, but it's more expensive. If you can get it done while you're still just dealing within the family, I tell people for guardianships, the judge doesn't want to see you and you don't want to see the judge. So the more you can avoid that, the better off you're going to be.
And I've never had a guardianship hearing that wasn't challenging emotionally, because you've got to go and speak in public about why this person needs guardianship. And it's very difficult.
It's an actual lack of capacity.
Mm-hmm.
So if you want to move to the next slide, the next most important thing is your advance directive. And I am happy to say that the governor has now signed a new bill. This is the Millennial Advance Directive, okay? So if I'm ever on life support, unplug me, wait 30 seconds, plug me back in and make sure it works. So you can kind of skip that one. I enjoy that slide though, okay? Yeah. So in Indiana, if you, the document that you sign, and the new changes in the law will go into effect July 1st of this year. So going forward, there's going to be lots of options about how we as attorneys draft up documents to make advanced care decisions. There's been an excellent program called the 5 Wishes program. We've not been able to have that in Indiana because we have statutory forms that control the living will, the healthcare representative, and going forward, there's not going to be a standard form. We're going to be able to draft documents that we think make the most sense. So the healthcare representative form, and we're also going to have remote signing. Mm-hmm. So unlike the will that you have to sign and assemble everything within 5 days, this gives you 10 days, okay? Because it's harder to get the medical signatures from the doctors and that type of thing. So we encourage people to have an advance directive. There's provisions in the new law about how you get that advance directive into your electronic medical record now, which is something you always want to make sure happens. But if you don't have an advance directive in Indiana, then you have healthcare by committee. So Indiana has a set of proxies, okay? So if you don't have somebody named, you can go to the next slide there. Yeah. So let's just say mom has no advance directive. She has 2 sons, one is a Republican and one is a Democrat. Gridlock. You need to call the ethics committee right away because they can never make a healthcare decision for you. And if you look at the priority changes in here, if you don't have an advance directive, then a guardian can make healthcare decisions for you. If it's not the guardian, it can be your spouse if your spouse is not the reason you're in the hospital, okay? It could be a majority of your children. It could be a majority of your siblings. It can be other people who are related to you, or it could be someone who's of care and concern to you, which I believe might be the Uber driver who has driven you to the hospital and wants to make sure they're going to get paid later on down the road. So if you want to skip over. Okay. So there's always been a question about what is an advance directive and what is simply a hospital policy. So one of the things that you see all the time under the healthcare representative, we have healthcare powers of attorney for now, but what's going to be happen as of July 1st of this year is they're slowly going to be phased out. So there's a 1.5 year period so lawyers can change their forms around. We're creatures of habit and don't change those very often. But if we drop a power of attorney after January 1, 2023, and it contains a clause that says this person can make healthcare decisions for me, that clause will be void. And so we don't want to do that going forward. The living will clause does not change in Indiana. I tell my clients living wills in Indiana as presently drafted are legally worthless. If you've ever read a living will document, it says this living will becomes effective once a doctor has certified in writing, I have a terminal condition, I'm going to die in a short period of time, and any kind of care you give me would be futile. And living wills only covers nutrition and hydration right now. Those are the last things you get to in the dying process. We do have out-of-hospital DNRs. One of the changes in the law, when we changed and allowed on the post form, a post form, which is a physician order for scope of treatment, I'll talk about in just a minute, can be signed by a doctor, a certified nurse practitioner, or a registered advanced practice nurse. We just changed that in the legislation, so the out-of-hospital DNR will be the same. So it's not just the physician, but the physician assistant who can sign the out-of-hospital DNR. If you have a advanced directive in the future, it's going to require 2 signatures, and one of those signatures can be a family member. So that could be the spouse that actually signs as a witness, which will make it a lot easier for us to get documents signed going forward. There are hospital policies. One is allow natural death, one's do not resuscitate, one is a no code. One of the problems with that in the past has been negative. So do not resuscitate. It sounds like you're not doing everything you could for mom or dad. So we now have what's called a physician order for scope of treatment, which is meant for, you can only have one of those documents if you're a qualified person. So you're chronically ill, you're medically fragile, a doctor would not be surprised you die within a year, and then you can say very specifically what you want or don't want to the medical community. Now that's not an advanced directive because you sign it once you know what your condition is. And this actually is a set of medical orders. So it goes into your electronic medical record. It becomes your personal property. It's on a bright pink form so you can't miss it. But it says on the back of the form, here's what I want for end of life care. I want CPR, I don't want CPR. Now, CPR performed in the hospital setting is only effective 13% of the time. They're going to break your ribs, they're going to intubate you and take you to the ICU. The EMS loves these forms. The last thing they want to do is chest compression on a 90-year-old person, okay? If you have the post form at home, do not put it on your refrigerator door. What could be more depressing? You walk by it every day. My God, I'm dying. I better get some ice cream. You know, and actually, the EMS is trained to look where your medicines are. So if you put that form there, your children should have a copy of the form. If you go to an institution, they're going to have a copy in your electronic medical record. And on the post form, you can say, I want CPR. I don't want CPR. You can say, do everything you can to keep me alive, or I want comfort measures only. I don't want to be in pain. I don't want to prolong life simply to prolong life. Or you can say, I want a feeding tube, try a feeding tube. I do not want a feeding tube. So it's a very flexible document. We accept out-of-state DNR or post forms in Indiana. As of July 1st, if you have a healthcare representative form or out-of-state sign, it's going to be accepted in Indiana. So the idea here is the law is now trying to get people to have as much freedom to make decisions about healthcare as they possibly can. There are some excellent resources out there that give you information about advanced directives in Indiana. There's the National Pulse website. We are an endorsed state, meaning that we've been using the form for several years now. We actively have pursued legislation. We're working to educate the community. The 5 Wishes program goes into some detail about what you might want or not want. The guy who developed the form actually worked with Mother Teresa, which is kind of an interesting thing. And then the last one, the Prepare for Your Care. We have been emailing back and forth. There's a professor in California that does this, and they're trying to come up with a simple form that people can understand at a 7th grade level for every state. And with the changes in Indiana law, we've been emailing back and forth about how they can change that form for Indiana. And I would assume before July 1st, that'll be ready to go and people can sign it. It has some really nice graphics in it, and it kind of explains what, for example, if somebody has dialysis, what does that actually mean? If somebody's going to have CPR, what does that mean? If somebody's going to have an out-of-hospital DNR, what does that mean? And it gives you options where you can say what I would want or not want based upon these circumstances. So this new law that passed, it's a Senate Enrolled Act 204. It's going to make it a lot easier to sign documents because we can do it remotely. if you're going to do it remotely, it's going to require 2 witnesses. A notary has to be actually face to face to be able to do something like that. And it also endorses telephonic signing. And it includes any type of technology that may be out there in the future. So if you could have your video phone and people can watch somebody sign, and the witnesses can interact with that person, they can identify this is the person, we know what kind of care he wants, and he has the capacity to make that decision, then you're going to be able to remotely sign these documents in the future, and they're going to be just as valid as if they signed in a lawyer's office. One more slide.
You just gotta
The
link.
post form, I just have it up there. It's going to be hard for you to read, but if you go to our website, you can see a post form, or you can go to the state health website. and
Yeah, we've
have
got
it
the
there.
link to the state site there, and there's a lot of good information about the form there.
There is a really, really good video. If you just type Indiana Post video into Google, then you're going to get about a 13-minute video thing that was done by doctors. And it really clinically goes through in a very easy to understand manner what options you have with the post form, when it would be appropriate, how you get it into the electronic medical record, and that type of thing. So I send clients to that website all the time to look at that.
And the last slide we've kind of covered already.
Okay. Yeah, we talked about the living will, so we're all done with that.
Yeah, that's it.
That's it.
Ready for questions.
So does anybody have any questions? I can't imagine you would, because that was all so clear.
And we didn't go fast at all.
No, we didn't go fast
Didn't
at
go
all,
fast at
no.
all.
Well, until we do have some questions, I just wanted to go back through the will a little bit. Typically, when we draw up a will, the first thing we do is we have kind of a recital about what is the family made up of. And one of the things that you could challenge a will based upon would be mistake. You made a mistake and you left out one of your 12 kids, you know. A lawyer did that and made a mistake when he drew up the will. So typically in a will, we would say, I'm married to so-and-so, I have this many children, she has that many children. If we're going to exclude somebody from the will, we have that written in there too. There are some dysfunctional families out there. We represent a few of those. I try and refer those to other attorneys. Not always successful, all right? So that is one thing. The next thing down is usually there's a provision about where does your personal property go? Many times people have some items of personal property they want to see going to one person or another person. And in Indiana, you can now have a memorandum that becomes part of your will that you can change from time to time without having to pay a lawyer to come back and change your will. So my Irish Catholic mother with 7 children, every January she'd say, we have to change my will around because so-and-so gave me this for Christmas and so-and-so gave me this for Christmas. And I finally got to say, Mom, you can do your own will now, you know?
Well, and putting stickers on the bottom doesn't count. I've had a lot of clients like, well, I'm going to go home, I'm going to put a sticker on the bottom of all my home wills, and that's going to say who it goes to. Don't do the stickers, do the written list.
Your clients must have more money. Mine use masking tape. So.
We're fancy.
Okay, yeah, use stickers. Yeah. The next clause then is usually what's called the residuary clause, and that's where the property is going to go. And then you have somebody named as the personal representative, and that's the person you trust to carry out the terms of your will. And that person becomes a fiduciary. In Indiana, when you open an estate, you have to publish notice in the newspaper. You also have to send a notice into the Medicaid office saying in case this person was on benefits and you have a claim, hey, we want you to send us a claim so we can send you some money, which is another reason to avoid probate in many situations, okay? In Indiana, estates have to be open a minimum of 3 months, and we don't have an inheritance tax anymore. So at the end of the day, once the estate is closed and once all the property is ready to be distributed, the personal representative can distribute that property and close the estate in a fairly quickly time frame. It used to be estates took almost a year to close because you had to do the estate, it had to be open 5 months. Once you get done with that, you had to send an inheritance tax return into the state of Indiana on green paper, and it took another 3 or 4
Get your
months.
closing
to
letter,
get your closing letter, and you had to pay that tax within 9 months. You got the discount of 5%. So things have changed a lot.
But for an estate that does linger along, we can make partial distribution. I have people think, well, I'm not going to see it. The beneficiaries are going to get impatient. I've got one right now where we're making a partial distribution. It's kind of getting delayed based on some real estate hangups, which isn't uncommon. But that doesn't mean you can't get some of the money out to the beneficiaries earlier, so that people don't get impatient. So.
Okay, does anybody have any questions?
It's a quiet group.
It is quite cool.
Well, I think we're an hour into this, aren't we?
Yeah, hey, I think we're close to the end here. We hope you learned a few tools and tips that you can transition over to your client interactions. We will have part 3 of the 6-part series next Tuesday at the same time from 11 to 12. That series next week is going to be special needs planning and guardianship. So if you have additional questions, you're intrigued, or you have colleagues that you think would benefit, please let them know, and plan to come and sit in with us for another hour of learning. And we hope you have some great takeaways. If you have any questions after the closure of this, go ahead and send an email. events@dhblaw.com is where you can reach us, or you can always call into the office, and we would be happy to answer any questions that you have. Thanks again for joining us, and we appreciate your time today.